So to the attorneys who are signed on, just as a reminder, Zoom does pick up and YouTube the faintest whisper. So anything that you would not want heard, you should make sure you're muted. I learned the hard way.
A lot of people have this too. Especially after recording became,
Yeah, it's not very nice. Not very friendly. You are here with your, just observing, right? Supporting and supportive? Okay, thank you. We're gonna call Mr. Tompkins first. So I'm gonna go get the judge. Mr. Walsh, if you want to sit up here with your client, that's absolutely fine. We better let Miss Richardson in because we're gonna need her. Good morning, Miss Richardson. Mr. Hebert, what case are you here on?
Good morning. I have King.
Thank you.
You're welcome.
Mr. Fabian Derek, Archie Morris is your client, is that correct?
Sure is.
Thank you.
Good morning,
Yes.
Deb. Can you hear me?
I can hear you, Miss Richardson. Thank you. We also have someone signed on as Galaxy S21 plus 5G. I cannot call your case if you don't rename yourself and let me know who you are. I'll give you a few.
Can you hear me?
I sure can.
Brandon Robinson, for the what's his name? Zoom 939-139-9384. Joshua Ober.
Are you a party to a case, Mr. Robinson?
Yes, I'm a victim for Joshua Ober.
Okay, this is also being broadcast via YouTube. So I'm going to go ahead and have you sign in and watch there. If you go to Google Access Kent Remote Hearings, Judge Denenfeld's name will pop up and it is on there right now also.
Okay, all right.
So
So get off of here.
Yep, I'll remove you right now. Thank you.
All right, yeah, thanks.
Okay, we'll go with what we have. Please remain muted until I call your case. Thank you. That's fun, isn't it?
There might be some more. Might be like, it's like, it'd be like before 2002, I think.
All rise, please. Circuit Court is now in session. The Honorable Paul Denenfeld presiding.
Please proceed.
Your Honor, do you want the lights dim for Zoom, or are you good with where it's at?
Dimmed a little bit, make it a little easier.
Okay, we have one dimming. And it's kind of dark, but I'm gonna leave it lit for now because the first one is in person. This is the People versus Jesse James Tompkins. This is case 1205099FH. Please state your appearances for the record.
Kim Richardson for the people.
Good morning, Your Honor, Pete Walsh for the applicant.
I didn't recognize you, Mr. Walsh.
I didn't realize Ms. Richardson was here on the case either until she spoke up. Morning.
Mr. Walsh.
Good morning.
Over this morning, he also prepared an.
Okay, very good. Let's see, are you Jesse Tompkins?
Yes, Your
Sir,
Honor.
I wonder if I could ask you to please raise your right hand. Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Thank you, sir. You can put your hand down. The matter before the court is an application to set aside a conviction. I will say up front that I believe I did get something from our local prosecutor's office saying that they did believe that Mr. Tompkins is eligible to have the conviction set aside. But of course, under the statute, there are a number of things that must be elicited on the record. And Mr. Walsh, I'm inclined to just turn it over to you if you'd like to interrogate your client about those things. That would be great. I do a lot of these, so you know, if you would prefer me to do it, but I'll turn it over to you. And then if you miss anything that I think the statute requires, I'll just ask you to cover it.
Your Honor, I would be fine with you doing it if you'd like.
Like I say, I mean, ever since Clean Slate passed, I probably have an average of 5 of these every Friday morning. So I've got a script and I go through it. But again, I don't want to deprive you of being able to do it with your client if you'd like.
I would not feel deprived at all, Your
Okay.
Honor.
All right, that's fair enough. So Mr. Tompkins, I'm now going to ask you a series of questions. Of course, I just put you under oath. And my first question is, do you have any pending criminal charges against you in any court anywhere at this time?
No, Your Honor.
There are, I believe, 4 convictions. Actually, I guess there's only 1 conviction that's before the court today. And that appears to me to be a January 28, 2013 conviction of either manufacturing or possessing a Molotov cocktail. Is that correct, Mr. Walsh?
That's correct, Your Honor.
So, sir, I wonder if, even though this goes back a long time, do you recall what your sentence was in? And I'm going to ask if you recall about any parts of it. And let me tell you what I'm typically looking for. Whether there was any jail or prison time, whether there was also or instead any supervision, meaning either parole after a prison sentence or probation, whether there were any fines and costs or restitution, and anything else that you could remember. Do you recall what your sentence was, if going back many?
Yes, I might be a little hazy on the details because it's been so long. I spent 2 or 3 months in jail, 200 hours of community service, and it was 2 or 3 years of probation that I got released on. And I also had to pay court fees and fines, off the top of my head, $2,000 to $3,000, but I'm really hazy on that detail. But I know there was fines.
And you successfully completed the probation and all of the conditions thereof?
Yes, I did.
Do you recall whether there was, since I know nothing about it, only the conviction, was there any restitution? Did the conviction involve any property damage?
No property damage.
Okay. All right. So as far as you know, you fully and successfully completed all parts of the sentence. Is that correct?
Absolutely.
All right.
Yes.
Without trying to pry into your private life, I cannot grant these applications unless I can make a finding that it would be consistent with the public welfare to grant your request. And so just tell me what you've been doing. I mean, I know it goes back a long ways. And again, I don't have to hear the entire autobiography. Just give me a sense of what you've been doing since you made this mistake.
Okay, I'm gonna keep it really short then. So I have a family, a wife who's very supportive, works for the state of Michigan. I have a stepdaughter who's 11 years old. I attend LCC, Lansing Community College. I'm working on getting my associates in construction management. To further my career, I started off as a carpenter. I also work as a construction site supervisor for Habitat for Humanity, which is very positive, impacting the community with my construction skills. And I also attend Epicenter Church in Lansing.
Very good. I mean, I appreciate that. I will say for the record that I did get a letter in support of you by my old friend and colleague, Ms. Benedict, who I see sitting in the audience. So that also is nice that she took the time to do that. Mr. Walsh, that is, from the court's perspective, what I need to cover, but let me turn it over to you if you have any additional questions you would like to ask.
Just a few, Your Honor. Mr. Tompkins, we originally filed this petition because you were looking for employment and thought getting this conviction set aside would help you in your employment. Sir,
Yes.
Is that correct?
Yeah.
You just obtained this job in September. Is that correct? The job site superintendent job with Habitat for Humanity?
End of August.
And are you planning on looking to advance either in Habitat for Humanity or another company up from job site superintendent?
Absolutely.
And is setting aside this conviction part of that, that goal,
That is a huge part.
as is going to Lansing Community College.
Exactly. They go hand in hand.
You've had a chance to review the records here. There are no other convictions, other than that reflected in these, records.
No, sir.
And to the best of your knowledge, with regard to that probation, you paid whatever fines and costs the court wanted you to pay before you were discharged from probation.
Yes, I'm positive on that note.
And I believe you indicated to the court that you have a stepson in the house. Is that correct?
Stepdaughter, yes.
Stepdaughter, and your wife is present here today to
Yes.
support you?
Yep.
And the two of you also own a home in the Lansing, area?
Yes, in East Lansing.
All right. I have no further questions.
Ms. Richardson, any questions on behalf of the people?
No, Your Honor.
All right. As I indicated, I did get a filing from our local prosecutor's office indicating that they did believe that Mr. Tompkins was eligible. We don't get very many filings from the AG's office, even though I think they're actually supposed to weigh in, but typically that just means that they're consistent with our local prosecutor's office. Let me make some findings based upon the evidence that's been elicited today. The court does find first that Mr. Tompkins did exhaust the statutory waiting period so that he could in fact bring the petition. He has indicated that he has no pending criminal charges against him in any court at this time. Also that he successfully completed all aspects of his sentence. And also based upon the testimony that I heard, it certainly appears to the court that granting the set aside would be consistent with the public welfare. Ms. Richardson, do the people take a position one way or the other on their request other than what your office already filed?
No.
All right. And so based upon all of those findings, I will set aside the conviction. Let me say this to you, Mr. Tompkins. People make mistakes. God knows I've made my share. It's really what you do about it afterwards. And it appears to me that you have done everything right. So I wanted to tell you on behalf of the court and on behalf of myself, how pleased I am to grant this and to thank you for the good works.
Thank you.
Now, my usual staff member who does motions is out with an ill child this morning. Do we have an order on this one?
Mr. Walsh actually did the
Oh.
order on the back of the motion.
Oh,
I can help you find it. By the sign here. You see the sign here tabbed under your.
oh, yeah, I do.
But none of the boxes.
Give me just a moment. These are scale form orders. And, I have to go through the boxes.
I figured I'd better stick to the form order.
You know, it makes it the easiest thing to do, and it is comprehensive. So. But there are a number of things I have to mark specific boxes. Does anybody recall what the statutory max is on this offense, or at least what it was?
What, Your Honor? I'm sorry.
The statutory max.
I don't recall, Your Honor. I did not handle it. I'm
I
not
get
certain.
the box I have to mark is whether or not he's requesting that felony punishable by more
Yeah.
than 10 years. Yes,
Your Honor, it was 4 years.
it's a 4-year. Thank you, Ms. Richardson. 18.
Yes.
Mr. Tompkins, I have signed the order. If you and Mr. Walsh want to just give us a few moments, we'll shoot both copies to walk out of here with.
Thank you, Your Honor.
Thank you very much.
I can keep all that paperwork.
Thank you, sir. And again, thank you for all the good stuff you've done in recent years. Shall we call the next one?
Yes.
Can you two just have a seat?
Yes.
Just in the back. I'll call the next one, and then as soon as she comes back with the copies, we'll get them to you. And happy Thanksgiving to all of you.
Thank you, Your Honor.
Your
You
Honor,
too.
The next case is the People versus Benjamin. I'm not sure if it's Free or Fris. This is case 2008283FH. Please state your appearances for the record.
I'm Richardson. People.
I apologize. William Shank on behalf of probation, Your Honor.
Thank you. The matter before the court here is a motion for early discharge from probation. So are you Benjamin Fris?
I am, sir.
Let's see, Mr. Fris, here's what Officer Shannick's motion says. It says that you were convicted of surveilling an unclothed person, eavesdropping, installing the use of device, et cetera, on November 15th of 2021. You were sentenced to a 1-year term of probation on January 12th of 2022. It also says you fully complied with the order of probation, including paying in full all of your fines and fees. You've served more than half of the order of probationary term, which statute requires, and also that it appears eligible for early discharge based on recent legislative changes. It's law amendments took effect. Gosh, it's already been probably 2 years or 3 years in October, so time flies. But in any event, this does indicate that there was a victim. Officer Shannick, did the victim submit anything here?
To my knowledge, Your Honor, victim services notified me that the victim letter was sent out on 10/18 about the court hearing and nothing's been received. Your
All
Honor.
right.
Thank you.
Fair enough. And so nothing new, Officer Shannick, since you filed the motion?
No, Your Honor. nothing.
All right. So look, here's what I always say in these cases, Mr. Fris, we ask a lot on probation. I mean, we understand that there are hoops that you have to go through. The intention of probation is to sort of say, look, you could have gotten, more time being locked up, but, we want to give you an opportunity to just show us that you can abide by some rules. And also, if it's appropriate, to be able to take advantage of some of the services that probation may offer, And as a result of that, it sure looks to me like you've done everything that we have asked in a timely fashion. And so I thank you and congratulate you for the effort. Is there anything you would like to say at this point?
I just wanted to say that the reason I'm seeking early release from probation is I've in the last year gotten married. We have an 11-year-old son. We bought a new home. My wife travels a lot for work. And with the few trips that we've known in advance, Agent Shannick has been able to grant permission to leave the state, which I've been incredibly grateful for. I am looking, there's 3 states in general that she goes to on a regular basis, which is Florida, Nevada, and New York. I'm in real estate and investments, and I'm trying to expand into those markets as well. That has been a bit trying being on probation and not being able to leave last minute or anything like that.
Right.
So in order to do that, to further my business, in order to take care of my family, it is pertinent that I am able to kind of be able to leave last minute. And that's why.
That's fine. And again, I mean, I appreciate you explaining it. You didn't really need to, but I'm interested in what you're saying. I mean, look, the bottom line is that, again, whenever this new it took effect October 1st, I just don't remember which year it was, maybe 2021 or something. So I don't know, maybe it's been a couple of years. Our legislature, signed into law by our governor, reformed a lot of our criminal law in Michigan. One of the things it did was to actually allow a person who's on probation to bring their own motion after 50% of the probationary period was filed, and then there are some qualifiers. You can't have had a violation, et cetera, et cetera. Here is actually your officer that is bringing it, which is also an indication to me that Officer Shanik thinks that you've done very well and that you've fully complied. And so to the extent that what we're always looking for on probation is just prove to us you can abide by some conditions. Some of them are no doubt onerous at times. But once you have done that, then there's no point in continuing to supervise you. So it also sounds like you've got, a lot of ideas about how you can benefit from no longer being on probation. And so I am happy to grant the motion. Ms. Richardson, do people take a position one way or the other on this?
Well, Your Honor, the notes from the file, it was in my case, state that they feel that the victim would have opposed this, but she didn't get back to us. So I'll leave that in your discretion.
Okay, fair enough. So it does appear as if the victim was served with notice, and victims make their decisions about whether or not they want to make a statement. So in light of all of that, I will grant the motion for early discharge. Officer Shanik, do you take care of preparing an order?
Yeah, I'll send it over within 30 minutes, Your Honor.
All right, very good. So, sir, you can essentially consider yourself off probation as of now.
Thank you, Your Honor.
Courts speak through orders, and so it's not technically until I sign the order, but it sounds like I'll be doing that probably even today. So again, I thank you for all of your efforts, and I wish you the best of luck and happy holidays.
Thank you, Judge.
Thank you very much.
Ma'am, you can step right up here. Can you pronounce your first name for me? Your Honor, this is the People versus Nashika Wheeler. This is case 1302607FH. Please state your appearance. Order.
Kim Richardson.
Yep. Okay. Thank you. And ma'am, I just want to be sure you don't have to have a lawyer in this case, and you're proceeding at least at this point by representing yourself. But do you have a lawyer here?
No, it's just.
Okay. I have to ask because if you do have a lawyer, then I have to work through your lawyer. But again, you don't need a lawyer to proceed in these cases. Okay. Fair enough. So ma'am, I'm going to ask if you would kindly raise your right hand. Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you, ma'am. You can put your hand down. This is an application to set aside a conviction. It appears to the court that we're talking about a 2013 conviction for an aggravated assault. It also appears as if I did get a response from our local prosecutor's office indicating that they believe that you do appear to be eligible for the set aside. I can't remember how long you've been sitting in the back. You may have already heard me ask some of these questions, but I'm going to go through essentially the same questions with you. And I guess my first question is, do you have any pending criminal charges against you anywhere at this time?
No.
And do you recall what your sentence was in this case?
Okay, a couple of things had happened with this case. Because this was my first time ever going to jail, ever. And it was with one of my child's daddy. And I know when I got arrested, they were trying to tell me it was a felonious assault, but it got dropped down to.
Sounds like it may have been pled down to, I think aggravated assault is a 1-year misdemeanor, or at least that's my impression. Ms. Richardson will correct me if I'm wrong about that. So it does sound though like you did you get some jail time as part of the sentence, or you spent some time in jail when you were arrested, or what? Okay,
when I got arrested, I was able to get out on that PR bond, or whatever it is.
Yeah.
And then I didn't know I couldn't go right back home when it happened, because he ended up coming back after I got out of jail, knocking at the door. And he called the police again on me, and they end up re-arresting me for being in my own place. And they were assuming that he was living there, and he wasn't.
Okay. Well, I do have the judgment of sentence in the case. And it does appear as if, let's see, you were placed on probation for 12 months.
Mhm.
And it appears to me that you did not receive any jail time as part of the sentence. There was a requirement of completing 40 hours of work crew within 2 months. Did you successfully complete that?
I did.
All right. It also says something about restitution to Ashley Wilson. Do you remember what that might have been about?
I think I had to pay something. I did have to pay something, I think.
Was who is or was Ashley Wilson?
It's a male. It's a girl name that he has.
That's what I was wondering is if it
He's
was
the father
person
of my
that-
daughter.
All right, okay. Yeah, Ashley can go either way, but as far as the name goes, but in any event, that's what I was wondering. So apparently you were required to pay Mr. Wilson something, and did you fully pay that?
I paid everything.
All right.
Your Honor,
Yes.
I hate to, but our notes say that there was a financial order to show cause in July of 2019, which he failed to appear.
Let's see. Do you recall that as a result? See, I don't think I have anything.
I don't
Let me
remember.
see what your office. The application of warrants setting aside the conviction. So I don't think that comes up in what your office filed, but I'm not doubting you that there may be something in your notes. And so your notes indicate that there was a show cause for what, not paying some of the financial penalties?
Yes, it was a financial order to show cause. And it was in front of Judge Lieber. And it says she failed to appear in July of 2019.
Do you recall any of that, ma'am?
It doesn't sound familiar, but I may have seen him one time.
Do you know whether or not you fully paid what you were required to pay?
I pay something in full, but I'm not sure if it was to him or if it was my fees.
Again, let me look at the judgment of sentence.
Your Honor,
Mhm.
if you wanted to call another case, she could go down to the clerk's office. They run that financial information on a different computer. So I'm unable to check to see if she is paid in full or not.
That's what I'm going to do. Ma'am, I'm going to ask if you will go down to the clerk's office on the second floor.
Mhm.
Do you have the paperwork that you filed with you, or should we? give
I
you a
left
copy?
it in my truck.
Should I just give her the judgment of sentence?
Yes.
So I'm gonna give you this particular document. And I need you to go down to the clerk's office, show them this, and ask them whether or not all of the financials have been paid.
Okay.
And then come on back and we'll recall the case
Okay.
at that time. And if you could even ask them to print something out verifying that, that would also be helpful to me.
Okay.
So take care of that, come on back, we'll recall the case at that time and we'll see what we can do.
Okay.
Thank you.
This for now. The next case is the People versus Joshua Ober. This is case 1404966FH. Please state your appearances for the record.
Kim
Yeah.
Richardson.
Sir, are you Joshua Ober?
Yes.
Good morning to you. Are you participating from New Mexico, sir?
I'm actually currently in Oregon, but I do live in New Mexico.
You live in New Mexico. Mr. Ober, would you please raise your right hand as I raise my own? Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you, sir. You can put your hand down. Mr. Ober, you have filed an application to set aside a conviction. The conviction before the court is a home invasion, second degree. And the date of conviction was September 29th of 2015. I did receive an email from the victim or victims in this case. I think I actually got it yesterday. The victims are indicating that they are opposed to the court granting this application. And I'll summarize it by essentially saying that they never received any kind of an apology and that this was a traumatic event for them, et cetera. So I do want to acknowledge, and that email was sent by Brandon Robinson, Alicia Coleman, and Brandy Robinson. And again, it says that me and my family, so I'm not sure which of those people, I think actually it may have been Brandon Robinson who sent it, were violated and disgusted with Mr. Ober kicking in our door, et cetera, et cetera. So I do want to acknowledge that I did receive that. Mr. Ober, I gather you are representing yourself, is that correct?
Yes, Your Honor.
All right, so I'm going to go through some questions with you. My first question is, do you have any pending criminal charges against you in any court at this time?
I do not.
Do you recall what your sentence was in this case?
If I remembered right, it was deferred sentencing for 2 years and then probation for 1 year.
That may be consistent with what I have. It looks like the judgment of sentence indicates you were placed on probation for 36 months. You were represented by David LeGrand, who is still a local attorney here, and that you did enter a guilty plea to a home invasion second degree. You were also required to make restitution to Alicia Coleman and Brandon Robinson, and also had a 12-month jail sentence suspended. Did you in fact successfully complete the probation, sir?
Yes, Your Honor.
All right. Sir, I wonder if you could tell me, in brief, and I don't want to pry, but I wonder if you could tell me what you've been doing with your life in a general sense since this conviction, which admittedly goes back a number of years.
I guess after my arrest, I got a carpentry job, kind of learned a trade that way. I've been doing carpentry work since. Recently, I was doing wildland firefighting this past summer. And that season's kind of over, so I'm going back to carpentry. I have bought property in New Mexico and I built a house.
All right. I do see that you did have a subsequent conviction in 2016 for what appears to be a misdemeanor, which was criminal trespass in Eugene, Oregon, in which apparently you were sentenced to fines. What can you tell me about that?
In 2016?
That's what I have. Let me see if I can find it, because I don't make this stuff up. So let me see where I got that from.
I was actually in Michigan at the time.
Well, let me see where I can find it. Yeah, so this is a printout of Joshua Stephen Ober. That's you, correct?
Correct.
And it indicates that let's see. Let me compare what the order here was, so this was 2015. You had a misdemeanor prior to this, but the one that came after this one, according to what I have in front of me, is a criminal trespass in the second degree out of Eugene, Oregon Municipal Court. And the date of conviction was February 11th of 2016. Now, you may have been living in Michigan then, but were you ever in Eugene, Oregon, in which you might have picked up a criminal trespass conviction?
No, sir. 2011, I think.
Well, let's see what I've got here, because what I have in front of me is difficult to read. In 2011, it was a criminal trespass second degree, and that was in the Eugene Municipal Courts. And then there's another entry on February 11th of 2016. I wonder if you did you fully complete whatever the sentence was in 2011, which may not have involved any jail. It may have been fines and costs or anything like that. Do you recall any of that?
I'm not sure that I did ever complete that. Maybe that is what happened.
Okay, all right. That's the only thing that that showed up in what I have. Ms. Richardson, do the people have any questions?
No, Your Honor, I don't have any questions of him.
All right, anything you would like to add in addition to what I already got from your office?
No, Your Honor. I would just agree with the victims on this case.
Okay, that's fair. And again, I mean, obviously, I take into consideration what I received from the victims. It's not part of the statutory criteria, except to the extent that I do have to make a finding as to whether it would be consistent with the public welfare. I mean, well, let me say this. Okay, first of all, it does appear as if Mr. Ober has exhausted the statutory waiting period for bringing the petition. It also appears as if there are no pending criminal charges in any court. It also appears as if all sentences were successfully completed, and that's regarding this offense, of course. This misdemeanor in Oregon, of course, is not the conviction that is performing. It also appears as if Mr. Ober has been working in a variety of different kinds of jobs. While I'm also troubled by the victim email, and I have no doubt that those folks are genuinely opposed to this because they were not happy with what appears to have been sort of what they consider to be a lack of remorse by Mr. Ober. It has been a number of years, and as a result of that, I will make a finding that setting aside this conviction would be consistent with the public welfare, and so therefore I will grant the petition. I've got some notes on my own cover sheet. Let me see what that was. Yeah, it was really just reminding me about the statutory language about public welfare and being consistent with it. So as a result, I will grant the petition. Now, sir, we're going to have to get an order done on our end, and since you're not in Grand Rapids, obviously at this point, would you like us to send a copy of the order to your Redwood Grove address in Jimenez Pueblo, New Mexico?
Yes, sir.
All right. So we will send you a copy of the order for your own records, and we'll obviously also get a copy to the prosecutor's office. Anything else come before the court in this matter?
No, Your Honor.
All right, thank you very much. Thank you, Mr. Ober.
Your Honor, I'm going to recall Ms. Wheeler's case.
Oh, good. Ms. Wheeler, come on up. What'd you find out?
Well, it looks like something that's going me both, or maybe half of it.
Yeah, I mean, it looks as if this doesn't actually reference a show cause, but that doesn't necessarily mean, this is really just kind of a printout about what was originally required and what has been paid. And it does appear as if there remains a balance in the case of about $554. And as a result of that, I'm going to deny the petition as of today. But if you can get that paid,
I can.
and then you can refile this, then I would certainly be inclined to say that you have successfully completed the sentencing, and then would be inclined to grant it unless something else comes up. For those reasons, I'm going to deny it today, but that does, what we in the law would call without prejudice, meaning that you can come back again. Okay?
No problem.
Thank you for that.
All right. Can I have that copy of paper or?
Of the paper you just got?
Yeah.
Yeah,
the
sure,
balance?
sure. We can make you a copy.
Okay.
Thank you.
The financial office is on the third floor. Do you want to talk to them and all about that? Okay.
Yeah, because the financial office may be able to work out a payment plan with you as well.
Okay.
Not much, but they can get it.
Yeah, I understand. Do you want a copy of that?
No, it's fine. I can
Oh,
give it
okay,
to you.
okay. Thank you very much. Happy holidays.
The next case, Your Honor, is the People versus Joshua Wabek or Wabek. There are three cases, case 22-09694 FH, 9766 FH, and 9801 FH. Please state your appearances for the record.
Kim People.
Michael
Kim-
LaQuigley for the defendant. Sorry, Kim.
That's okay. Kim Richardson for the people.
Good morning, Mr. LaQuigley.
Good morning, Your Honor.
I had already said good morning to Ms. Richardson. I'm not excluding her. She's
been here,
with
I've
us.
noticed.
She's been with us for a while. The motion before the court is a motion for a bond reduction. Mr. LaQuigley seeks a bond reduction in this matter. It does appear to the court as if Mr. Wabek or Wabeki, however he pronounces it.
Wabek, Your Honor.
Okay, Wabek is charged with operating while intoxicated or impaired, third offense, and a failure to stop at the scene of a personal injury accident. It also appears as if he's been in custody since September 21st, 2022. Apparently because he picked up a methamphetamine charge, and that a bond was set in the 61st District Court. And then trying to figure this out. Oh, he may also have picked up a charge on a financial transaction device, apparently also in the 61st District Court, and that was set at $7,000 cash or surety. Is that your understanding, Mr. LaQuigley?
That pretty much sums it up. Yes, Your Honor. He's seeking a personal recognizance bond on all of, well, on the biggest charge, so that he could make bond on the others and bond out.
Yeah, okay. And would you like to add anything, Mr. LaQuigley, other than what you filed?
I would, Your Honor. I would like to point out to the court that Mr. Wabek has never failed to appear on a bond. He's served probation several times and has successfully completed all of those probations. His guidelines, as I score them on this matter, are 0 to 17. So it's very likely that once sentencing comes along, he would at least qualify for probation at that point. His mother is ill and his elderly father is caring for her. He would like to be able to help his father, at least while he's awaiting sentencing here. He has a place to live with his brother, which is on a bus route, so he won't be driving anywhere. He has a job awaiting him, and he is participating in counseling at this time. He very much would like to be able to be out and help his elderly parents, and then face whatever consequences he has to at the time. Thank you.
Fair enough. Thank you. Mr. Quigley, I also have something indicating that your client may already have a hold on him out of Ottawa County in a child support case. Do you know anything about that?
He does, Your Honor, and he expects to go there and resolve that matter. If he's released from the bond here, he would go directly to Ottawa County and handle that matter. He has the funds to erase those arrears and take care of that matter were he out of jail at this time.
All right. Ms. Quigley, excuse me, Ms. Quigley, Ms. Richardson, do you take a position on this?
I do not.
All right. Well, I've got a lot of problems with this one, and let me tell you why. It appears to me that this would be Mr. Wabek's fifth drunk driving. According to the criminal history that I have, he picked up an OWI third in 2010, another OWI third in 2017. And now he's charged again with an OWI third. At least that's what it looks like potentially to me. He's also had a probation violation out of this court in 2018, in which he was sent to prison for a period of 18 to 60 months. And again, apparently since this case began, he's also picked up a couple of charges, of course, of which he is presumed innocent. But it is not exactly a record or background that instills the court with a great deal of confidence as to whether in fact he would potentially be getting behind the wheel again, and secondly, as to whether he is somebody that should be trustworthy. And again, another issue that really concerns me is that he's not just charged with the drunk driving, he's charged with failing to stop at the scene. And so while I can certainly be sympathetic to parents and all those other things, in light of all of that, with all due respect, I'm going to deny the motion.
Thank you, Your Honor.
Thank you very much. Appreciate it.
Have a nice day, everyone. Happy
Thank you.
holidays.
And to you, Mike.
I'll go back and look because it's not with one.
Oh, you know what? I took it home. Yes. It may be in my desk. Do you want me to go grab it?
No, I'm gonna call the next one. Your Honor, this is the People versus Scott King. This is case 2107588FH. Please state your appearances for the record.
Kim Richardson for the People.
Attorney Evan Hebert on behalf of the defendant. Good morning.
Good morning, Mr. Hebert. This is a motion for an early discharge from probation. It appears as if the offense was an attempted aggravated domestic violence second. And the motion indicates that the defendant has completed his probationary terms, has not violated probation in the preceding 3 months, because it has to be 50% of the original term. Indicates that he has reasons to want to travel to Texas, and that he is not a flight risk. I then did also get something from the probation officer in the case, Nikki Glass, who indicates that Mr. King's transfer to Manistee County was accepted back in May, that he's completed his community service and anger management, has maintained employment, paid fines and costs, but she says he has not paid in full all of his fines and costs, at least as of the last report. And this from her is dated October 28th. And that he's reported as directed, has not had any violations, reports being 18 months sober, continues to attend AA. And overall appears to have done very well on supervision. Ms. Richardson, do the people take a position on this?
Your Honor, I guess I would ask for it to be denied until he fully pays his obligations.
Yeah, all right. That's what I'm going to do. I mean, what I'm going to do is I'll hold it in abeyance until I can get Ms. Glass's confirmation that in fact all of the fines and costs have been paid. And then once I receive a confirmation of that, I will go ahead and grant the early discharge. Now, you know, again, I got the report maybe something like 3 weeks ago or something like that. And it's possible that Mr. King has in fact paid everything in full, but that really does have to be done before I can early discharge. But it certainly sounds as if he's done very well on probation. So I'm not going to deny it at this time. I'll hold it in abeyance. And once I get confirmation, I'll go ahead and grant the early discharge. Okay?
Thank you, Judge. May I ask one or two questions?
You may.
What is the outstanding amount? Is that on the letter?
That it does not tell me that.
Okay.
It does not give me numbers. Here's what it says. It says he reports he has paid on his fines and costs. Now, you know, so the language doesn't say he reports he has paid in full. It says he reports he has paid on his fines and costs, but as of his last report, he had not paid in full. That's all I have. It doesn't give me numbers. It doesn't, you know, really give me any of that. I mean, I might be able to see. Now, see, I don't even think I don't even have the judgment of sentence, so I don't know what the fines and costs were, what they totaled. But so he just needs to pay all that stuff off. Other than that, it sounds to me like he's done fine, and I would have no problem granting him early discharge.
Thank you, Judge. I do have the order of probation in front of me. It says $1,258 was the total. So we will confirm that.
Does it indicate whether, you know, or how much he has already paid?
No, the order is dated March 2nd of 2022. So this is at the time of the sentencing.
Yeah, okay. So again, I mean, you know, if he can get that stuff paid off, I got no issue with granting him an early discharge. It sounds as if his behavior has been very good.
Thank you, Judge.
All right, thank you very much, folks. Have a nice weekend.
The next case, Your Honor, is the People versus Mark Bolster. This is case 2200522FH. Please state your appearances for the record.
Kim Richardson for the People.
Val Foster on behalf of Mr. Bolster.
And good morning.
Good morning.
So this is a competency matter. It's a motion for a hearing on defendant's competency to stand trial. I believe that the court did receive a written report from the forensic center finding that the defendant was incompetent to stand trial. But I don't have that report. And so I wonder if either counsel has the report, because if it was a finding of incompetency, then the question becomes, was it restorable competency, or was it not incompetency or not restorable? My understanding of the law here is that if it's a finding of non-restorable, then the prosecutor's office would normally file a motion for a commitment. But if it's restorable, then my options would be to either order that he be committed back to the forensic center so that they can try to restore competency, or I also had the option of trying to get that done on an outpatient basis. But I never got the report here, which is unusual.
May I read the report? Okay, it's dated October 19, 2022, addressed to this court, Judge Denenfeld from Andrea Vandenberg, hospital director, Center for Forensic Psychiatry. The most pertinent information from the letter indicates if the court determines that the defendant is incompetent to stand trial, but restorable, and the Department of Health and Human Services is named the medical supervisor of treatment, please note that in accordance with the State of Michigan Department of Community Health Administrative Rules, R330-179, the Center for Forensic Psychiatry will offer a placement recommendation for treatment to attain competence, which will be for inpatient commitment within a State of Michigan hospital. Upon receipt of a court order committing the defendant to undergo treatment to achieve competency to stand trial, we will offer a placement recommendation regarding which State of Michigan hospital will provide this treatment. Does the court need anything else?
And can you, Ms. Foster, can you just read to me the actual finding, which I gather is that they found him to be incompetent but restorable, but I need to hear that if you don't mind.
Absolutely, sir. It's indication to opinion. It is this examiner's opinion that Mr. Bolster is not competent to stand trial at this time. Let's see if she says later in the document if he is restorable. Okie dokie. It probably will be on the last page. Here we go. Okay.
It's my understanding he's likely to regain competence.
Yeah, I see that too.
Okay, and so
may attain competency within a time of 4 days. Is that what is that the language the court is looking for?
yeah, I mean, it is. And so therefore, and I also don't have an order attached here, but I mean, I know that there are standard orders. And I think that likely means that I'm going to mark the second box just because I've had a number of these on the order, because I think that's the one that says incompetent but restorable, and to commit him to a facility to attempt to restore his competency. I mean, I don't know why this has come to me in this form, because normally I would also have one of those form orders. I'm not criticizing, but I don't have that. And so that's what I'm inclined to do. Do both lawyers agree that based on this finding, we cannot proceed towards trial at this time, but that what I should be doing is to committing him to receive treatment at a designated facility, and then they meaning the forensic center would then keep us apprised as to when they believe that competency has been restored, and then at that point we would simply put it back in the normal course of events. Does Ms. Richardson, does that sound like what I should be doing here?
I believe so, yes.
And Ms. Foster, do you agree with that?
I would agree, Your Honor.
Okay, so we'll get, Scale has a form order here. We'll get the Scale form order. I'm almost certain it's the second box, but don't quote me on that because I had one of these pretty recently. But I'll mark the box that says incompetent but restorable, and then ordering the forensic center to designate a facility for him. Of course, we'll get you each a copy of that order, and then we'll just simply await for an update. Okay, anything else come before the court in this matter?
No, sir. Thank you, sir. And everybody stay safe and happy holidays.
And thank you, Ms. Foster. Anything else, Ms. Richardson?
No, Your Honor.
All right, thank you very much.
Your Honor, I think that order usually comes over from one of the attorneys, but I'm not sure which one. Are they able to get that to us?
I think
it's from us.
Oh, okay.
I'm sorry,
Either one. We'll make sure you get it.
I would appreciate it because, I mean, I could probably find it in one of the Scale court forms, but if you could get it to me, that would just facilitate it, and I appreciate that.
I think it comes from the prosecutors. Does it come from your office, Kim? I'm pretty sure it does.
No, I saw something in Carpel, so I just sent it to Deb. I'm hoping that's it. If not, please, Deb, contact both of us.
Sure.
Great. All right. Thank you very much. Thank you, Ms. Foster.
Your Honor,
All righty. Have a good one, folks.
Thanks. You too.
is the People versus John Hahn. This is case 2105737 FH. Please state your appearances for the record.
Kim Richardson for the people.
Good morning, Your Honor. Dan Watkins on behalf of the John Hahn.
All right. Good morning to you, Mr. Watkins. The matter before the court is defendant's motion to modify bond in this case. The defendant pled guilty to one count of ethnic intimidation. He's scheduled to be sentenced on January 4th of 2023. He has been in jail since June 24th of 2002. Mr. Watkins believes that the sentencing guideline range will likely be either 0 to 11 months or 0 to 17 months. He indicates that Mr. Hahn has a home that he pays rent on, and that if he stays locked up until sentencing, he will have served almost 6 months in jail. Not a danger, not a flight risk. And that is essentially the motion. I did get a bond motion report from court services. He did fail to appear for a status conference in February during the pendency of this case, and he was remanded without bond on June 28th, 2002. So obviously a prior failure to appear does not exactly cut in his favor. And that court services says that if he were to be released, he would reside at his residence in Grand Rapids. He provided a telephone number at which he can be reached. He is unemployed, but apparently receives disability monthly. And he has a pretty significant criminal history, which is 4 felonies, 18 misdemeanors, 1 bench warrant, and 1 bond violation. Court services' ultimate recommendation is that they are not opposed to bond being set, but they do not recommend a personal recognizance bond. Mr. Watkins, will give you a chance to add anything you'd like.
Oh, thank you, Your Honor. We would ask the court to consider reinstating his original bond, which I think was either $1,000 cash surety or 10%, because I believe he did post $1,000. We just did not want to take away the court's opportunity if the court was inclined to want to sentence him below the mid-range of the guidelines. So we wanted to bring this motion to possibly either modify bond or reinstate bond. This situation is involved, obviously, ethnic intimidation, but this was not a situation where Mr. Hahn knew the victims.
No, but look, I don't mean
kind of.
I don't mean to interrupt you, Mr. Watkins, but let me ask this. This may be the only ethnic intimidation case that I have currently going. Is this the incident that happened in the hotel parking lot?
No, Your Honor. This incident happened in a park. Mr. Hahn was at his by his bicycle, and there was a couple who were checking the park out for, I think, a possible wedding venue. And
yeah, he's coming back to me. Yeah, this was written up.
He has some substance abuse issues in his past, and medications, and quite possibly some psychological issues. And so this wasn't anything where he had an ongoing beef with these particular people. This was just
well, I understand that, but
verbal outrage.
But I mean, do I recall this incident correctly, that these people were just in the park and he just started unloading with a series of racial epithets to people that he had never even met? Is that this incident?
That is this incident, Your Honor.
And
yes,
wasn't he also suggesting that they had no right to be in the park?
Yes, I do believe. I don't know everything that he said, but yes, that is the gist of this, and he has since recognized that his media intake largely affected his behavior that day.
Well, you know, my media intake, which is, I'm sure, quite more limited than his, has certainly ruined me. So, you know, that's a powerful argument. Ms. Richardson, do you take a position on this?
I don't, Your Honor.
All right.
I can tell the court that the victims have been notified, and they said they would leave it to the court. They didn't really have a problem with him getting out. They just really hope that he's been educated by this.
Fair enough. Magnanimous people. And so here's what I'm going to do. I'm going to set bond at $2,500 or 10%. Which means that he, friends, family can post $250 with the court clerk's office in order to get out. I do recognize that he's on disability, but I have to tell you, there are a number of things here that really concern me. One of them I don't need to belabor, but it was outrageous conduct here. I mean, it was completely uncalled for, offensive, racist, and a bunch of other things. It's still a free country. People get to be racist. What they don't get to do is to select victims on the basis of their race. And also the fact that he has a terrible criminal history. I mean, he's got 4 prior felonies, 18 prior misdemeanors, et cetera. So I'm just providing a rationale for why I am going to require some money to be posted, but $250 I would hope he could potentially come up with the help of friends or family. I do recognize that apparently the guideline range is an intermediate sanction cell, and so I understand that if I don't give him some chance, he may well have ended up already serving much of what I could sentence him at the end of the road. And so that is the court's decision. Now, Deb, what do we do? Does Mr. Watkins present us with an order, or do we do that? We have Mr. Watkins, we have already sent a greeter to the jail advising them of what my decision is. And so presumably that means that the 2,500, 10% is now what the bond has been set at.
Thank you. Thank you, Your Honor.
Okay. Thank you very much, Mr. Watkins. Have a nice holiday and weekend.
Oh, thank you. You too.
Thank
Ms.
you.
Richard-
Bye,
Ms.
everybody.
Richardson, is that
Yes.
it for the criminal motions you have?
I believe so. There's just, if it's just Archie Morris left, Mr. Lockman's on.
That is all that I
I
believe.
think that is I think that's the last one that we have on criminal stuff.
Okay. I'm gonna go
Oh,
ahead and go back, please.
And happy early birthday, Judge.
Oh, thank you. And I guess I'll probably see you next week before the holiday, but in any event, thank you very much.
Bye.
Your Honor, the next case is the People versus Derek Archie Morris Jr. This is case 2102851 FC. Please state your appearances for the record.
Blair Lockman for the People.
And good morning, Your Honor. Pavel Fabian here on behalf of Mr. Archie Morris.
And good morning to both of you.
Your Honor, before you get started, I must tell you that there was a Brian Robertson who signed on earlier, and I sent all the victims to watch on YouTube. I was informed that he actually would be able to make a statement if he chose to. I've been trying to have victim witness get him back in.
I'm confused. In this case,
In this case,
this is a pre-trial motion. I guess I'm not quite sure.
All right, Deb, the email I sent you about Mr. Robinson was relevant to the expungement case where
Okay.
apparently they'd had the statement sent over anyway through email to the court.
Okay, perfect. Thank you.
Thank you for that clarification. So I'll refer to this as the case that just doesn't stop giving. And so the motion before me is the defense motion to admit evidence under Michigan Rule of Evidence 404. I have had a chance to read both the motion as well as the people's response to it. Let me just give a fast summary before I turn it over to counsel. As I understand it, and again, this is hardly the first time we've dealt with this case. It involves an incident that happened on November 2nd of 2020, in which it appears that alleged, but some of this I don't even think is really at issue, that the defendant, Mr. Archie Morris, shot and killed a victim named Giovanni Albelo outside of, I think, the Wealthy Street Market. Again, based on what I have gleaned from the papers, the defense position here, or at least their version of events, is that Mr. Archie Morris and somebody named Jalen Ruffin were in a vehicle, that the decedent, Mr. Albelo, and Mr. Ruffin were involved in an ongoing feud. Again, I say this is the defense version. that the decedent, Mr. Alvelo, shot or at least attempted to shoot at Mr. Ruffin in the vehicle, and that is when Mr. Archie Morris, the defendant, shot the decedent, Mr. Alvelo. And the defense theory, as I get it, is that Mr. Alvelo, the decedent, did not see Mr. Archie Morris in the back seat of the vehicle when Mr. Alvelo approached the vehicle and shot him. And both of you can correct me, but I'll go to you. Is that a close version of what the defense theory is here, Mr. Fabian?
Yes, Your Honor. I think the court stated pretty concisely. I think the disagreement, or I guess the case really turns on the defense kind of consistently has said that, yes, Mr. Archie Morris was acting intentionally, but also he's responding to a sudden violent attack. And the reason for the sudden violent attack is because of the beef between Mr. Ruffin and Mr. Alvelo.
Yeah, I get that. I do. I get that. But thank you for that. And so the motion before the court is that the defense wants to present character evidence of the decedent, Mr. Alvelo, through opinion and reputation testimony pursuant to MRE 404A2 and using MRE 405 with respect to reputation or opinion evidence. Then, as I read the motion, the defense also wants to present specific instances of conduct per MRE 404B1 to show that the decedent, Mr. Alvelo, had the motive or intent to shoot Mr. Ruffin. The prosecutor did file a response, in part saying that they do object to the admissibility of the conduct that occurred on September 11th, 2020, which is also referenced in the defense motion, in which the decedent, Mr. Alvelo, and another shot at a rival gang's van. The people's position on that, I'm sure Mr. Lockman will expound, but the people's position on that appears to be that they just think it's irrelevant and that it also fails under the MRE 403 balancing test. And again, Mr. Lockman, you'll obviously get a chance to say, boy, Judge, did you ever screw that up? So, but we're not to you yet. Let me first have Mr. Fabian tell me how badly I screwed it up from his perspective. So, Mr. Fabian, why don't you go ahead and take it over? It's your motion.
Yes, Your Honor. Thank you. As I sort of said, the defense position is, which is Mr. Archie Morris is responding to a sudden violent attack. I think it's important for the court to sort of think about the other side of that coin, which is the prosecutor's position, which is their from previous motions are labeling this as some sort of mutual combat. Okay, if that's true, then it would make sense for the jury to understand whether or not Giovanni Alvelo was the probable initial aggressor. 404A2, and this is regardless of whether Mr. Archie Morris knows who the shooter is or not, his reputation can come in for the exact purpose that he was probably the first person to act aggressively in this situation, which again goes to the defense theory and undermines a little bit the prosecution theory. So I think the evidence clearly falls within the exception to the rule. And I think the response was something like, well, he's saying he doesn't know him. But that's not really relevant to the analysis because we're not saying he's responding because he knows him. We're saying it's more probable that Mr. Alvelo was the initial aggressor here, and his reputation evidence can come in for that purpose. Turning to the 404B, as a starting point, it's a rule of inclusion and not exclusion.
Oh, how interesting. A People versus Vanderbilt reference. I like it, Mr.
Well, I get to read that quote quite often.
Usually when it's being used against you. Yes, I get that.
Yeah. Yep. So I think sort of along with the defense theory here and, the reputation of evidence showing that it's probably that he was the initial aggressor, it would make a lot of sense for the jury to wonder, or a juror might ask themselves, why would a guy jump out of his car with a gun and fire at some other person in a parking lot? And so here, the 404B evidence, in particular, the fact that, and it's not in dispute, that Ruffin had shot at, and there's testimony about this, had shot at Mr. Alvello and his girlfriend, who was in the car at the time they pull into the parking lot, would clearly give him motivation to do that. But when I talk about the September incident, because this is also not in dispute, Mr. Ruffin belonged to the Bemis gang, and Mr. Alvello belonged to, I think the testimony is either the North gang or North Park, something like that. Anyway, a rival gang. And so even if Mr. Ruffin hadn't shot at them 2 weeks before this incident, he would also be separately motivated. Maybe this is just additional motivation to shoot at him because he is in a rival gang. And so to me, that also kind of bolsters the idea that he was probably the first aggressor and would explain why he intended and was motivated to kill Ruffin, who's sitting in the front seat. It would explain his actions on video to the jury in a way, contextualize them in a way that they otherwise wouldn't know.
Apply Vandervliet and its test to the September 11th incident, if you could.
Sure. So if the only thing we knew about, I guess let me back up, because we know he's got motivation and intent to kill from the 2 weeks before shooting. And so to me, it just I guess what the court is asking is, what is the character non-propensity purpose for which is being offered, and how does that balance against the competing factors of prejudice versus its probative value?
I mean, that's essentially what I'm asking.
Yep. And so I think my response is that's one additional layer of motivation to shoot at Ruffin. Because I don't think there's any record evidence. That's it's not clear whether Mr. Alvello, was shooting at Mr. Ruffin because he had shot at them 2 weeks before or because he was in a rival gang. But Mr. Ruffin was clearly in the gang he had been shooting at about 2 months before this. And so there might be multiple motivations. It's not clear which one, but either by itself is a significant enough motivation to get him out of the car and conduct what I've been labeling as a sudden violent attack on Mr. Ruffin without knowing that Mr. Archie Morris is in the backseat at the time.
And so if we're talking about 404B, you're suggesting this would be offered to prove what? Motive or intent?
Yep, it would prove it would prove the motive, that he had a separate motive just because they were in rival gangs and because he shot the exact same gang before. I don't think that's disputed that Mr. Ruffin belongs to the Bemis gang, the exact gang he's shooting at 2 months before. So that is a entirely separate motive from just him being shot at, which I don't know if it's clear that he knew that he was being shot at by Mr. Ruffin. That's the belief. But those two things separately are separate motivations to shoot at Mr. Ruffin in this case.
All right, fair enough. Mr. Lockman.
Just a few things. I think our response brief pretty much covers this. And I think I think we're, number one, towing a very dangerous line into propensity. Number one, we don't dispute. That's why we agreed to the prior incident, because it goes to our case why Mr. Alvello walked out of that car with a gun. Whether he was intending to initially shoot or not, I think the expectation from Mr. Alvello was that there was going to be an exchange of gunfire. And that was because 2 weeks prior, with the same driver, Mr. Ruffin shot at him. And that's why we've conceded that that should come in, because it goes to bolster our case that Mr. Archie Morris and Mr. Ruffin, once they saw our victim, were ready to engage in a mutual combat. But going back 2 months, it's just pure speculation that, okay, well, he's shooting him because 2 months prior or three, whatever it was, several months prior, there was a shooting with rival gang members. The fact is, and this is going to be new to Mr. Fabian, I guess, but Mr. Archie Morris lists himself as the Uptown gang. We have Brandon Romero, who's going to testify that Bemis and Uptown are the same gang. So that opens the door to Mr. Archie Morris being brought in as a rival gang member who has the equal motivation to shoot back at Mr. Alvello. Same thing with the character evidence. If he raises the character evidence of our of Mr. Albello and being someone who has had prior instances of, or has a reputation or opinion of being a violent member. I will also, that opens the door, as was noted in our brief, to Mr. Archie Morris's propensity for violence and for carrying guns, to the extent even that when they arrested him, they refused to go into his house. Police, SRT, refused to go into his house because he's known to carry guns and use them. They waited for him to leave his house. So, I mean, again, towing a dangerous line, and then how much, I mean, this is going to be an accordion. How wide are we going to spread this? We've acknowledged one incident. We're conceding that Mr. Albello had a gun, that this was the likely probability that there was going to be exchange of gunfire between these two parties, that the motivation was the shooting that happened 2 weeks prior, that they are rival gang members that don't like each other and that have had incidents before. I don't know why we're going beyond that. And as noted, Gio Albello's motive or intent is not what's at issue in this case. It's what was in Derek Archie Morris's head when he fired his shot. That's what's at issue in this case. And it's going to take us away from the focal point of the trial. I understand his only purpose is to use this to show who's the initial aggressor, but the reality is, since we've conceded all these things, including him walking out of the gun, the only reason they're doing this is to show propensity, to show that Mr. Albello engages in this kind of combat all the time, and therefore that's what he was doing here. And like I said, number one, I think that's not allowed by the rules. And number two, it's going to open the door to both Derek Archie Morris and Jalen Ruffin's behavior, which sort of bolsters our theory that Mr. Archie Morris was at the ready with a gun in his hand and ready to fire a shot. And quite frankly, Your Honor, this is all on video. I mean, every part of this is on video that's significant. The jury's going to see who the initial aggressor was. They're going to see the time periods that it took to fire shots. They're going to be able to see everything. And I don't know what the defense's case is. If they open the door to the proffer, then that'll come in that way. Otherwise, they will get from other witnesses, they will get an idea of what was going on in this case. And I think we're just going far away from what's needed. We're conceding the one incident that took 2 weeks prior. We will get into that ourselves. I don't think we need anything more than that. And again, a very dangerous slippery slope when we get into the character, because I don't believe they're getting into Mr. Albello's character for the purpose of showing who the initial aggressor is. They'll see who the initial aggressors are. They'll see what this is without the need for any of this additional input. But if we're going to do that, we're just letting the court know that we intend to get into Derek Archie Morris's character for violence.
Well, you would agree, Mr. Lackman, that the court can always give a prior act instruction to the jury, limiting what they can consider the evidence for. Isn't that right?
Sure, you can give a limiting instruction, but that's not what the jury is going to. I mean, we've been doing this a long time. If it's unnecessary because they have everything in front of them, we're just opening the door for the jury to start expanding what they're supposed to be judging this case on, which is the facts and what they see and what they will see on the video.
Well, I get it, but my understanding of what the defense is doing here is to try to give their version of what the motive or intent was.
But Your Honor, we're conceding. We have, that's the one incident. We're agreeing to the one incident that's close in proximity, close in time. We have conceded that. So the motive and intent is coming in, quite frankly, from both sides. In other words, we'll show that it's their motive and intent. They're willing to shoot 2 weeks prior. They're willing to shoot this day. But I don't know why we have to expand that accordion, go that far affray. They're going to get the motive and intent of both parties in the case in chief. I think it opens up a door, and it's a great risk, both of prejudice and of confusing the jury and misleading the jury, because there's no other way, there's no other purpose for this evidence than to show propensity of the victim. There's none. We haven't opened that door. We could have done it with Derek Archie Morris. We could have done it with Jalen Ruffin. We haven't opened that door. And if they want to open the door, then it's open wide and it'll all come in.
Mr. Fabian?
Well, let me start. I guess that was news to me that their intent to introduce some sort of gang evidence, because
It was introduced at the prelim.
Okay, but separately, I guess on the motion, I think the jury would be much more confused if they didn't understand why a human being might step out of a car with a gun and fire at another human being, if not for either because he knew he had shot him 2 weeks before, or because he knew that he was in a rival gang and had no issue firing a rival gang, and so he'd be motivated to do that in the instance.
That's
Both of those-
propensity.
both of those incidents also bolster what is the defense theory, which is he was the initial aggressor, which gets back to the self-defense in the case. There's absolutely, and this was testimony for the preliminary examination, the second time around on page 47, the detective was specifically asked, is there any beef, any kind of beef, any known beef between Mr. Archie Morris and Giovanni Alvello? And the answer there was no. I'm aware of absolutely no beef, something to that effect. And therefore, it would make little sense if there was no beef between Mr. Archie Morris and Mr. Alvello, that he'd be shooting him for any other reason than he's committing a sudden violent attack, which again underscores why it's important for the jury to consider that he is the initial aggressor. And that's the reason the evidence is being, that's the reason we're looking to admit the evidence, is to shore up the defense.
Judge, just to follow up on that, the question was asked of one detective out of, in the years, probably dozens and dozens of detectives who may be aware. This detective who works domestic violence unit is not aware of any beef, and doesn't do gang cases, is not aware of any personal beef between Derek Archie Morris and Giovanni Alvello. That doesn't mean it doesn't exist. It doesn't mean that their rival gangs don't have that beef. And we've acknowledged from that prior incident of the prior shooting, and we'll get into the gang stuff. He can get into the gang stuff. Other acts and Gio's character is the only purpose for Gio's character is for propensity, and the other acts are just cumulative and prejudicial. We have agreed to the one act to show the motivation and to show the gang motivation. And I don't think we need to compound it. If the prosecution had brought in a number of 404B cases and piled on, this court I would expect it to say, this is cumulative, it's repetitive, it's unnecessary. You're getting what you need from what we're giving you, from what we stipulate to and agree to.
Well, I mean, we all understand that the general rule is that propensity evidence is not admissible, but there are all of those exceptions, the ones where the people have to give notice if they're offering it for a different purpose. That works both ways, yes?
Not the notice part, but yes.
I'm confused by the question, Your Honor. We do give 404B notice.
I understand, and what I'm saying is
we are agreeing to the one act that took place prior, where there was a shooting that took place, and that's I think that's I don't know.
I just want to be clear, and I'm not arguing with you, Mr. Lockman. I mean, I'm just trying to understand myself. I mean, now it sounds like that it's sort of, I don't want to use the word shifting because I'm not suggesting you're intentionally doing that, but it feels to me like we've just gone from propensity to cumulativeness.
Well, I mean, my point has been from the entire discussion, it is cumulative, but my point the entire time is the reason they're doing this, because we've already gone into this at the prelim and he was aware that this testimony was coming in. The only reason we're going further is because what they're trying to show is propensity. They're trying to show, because my victim has previously fired shots, that he's doing it in this case. And that's the purpose, because we've conceded all the things he's trying to get in, we've conceded. We haven't disputed it. Now, the only part that we dispute is the initial aggressor portion, which is only one element, of course, of self-defense. But we've conceded all the things that he's asking for, but he's still asking for more, to bring in more evidence to show it. Why? We're not getting up there and saying that they aren't rival gang members. We aren't getting up there and saying that both had guns. We're not getting up there and saying that they both haven't shot each other. We're not doing that. we've conceded, so the only purpose he could be doing this for is to show propensity. He's trying to cloud the jury's mind and say, look, this guy victim is a violent person, so therefore it subjects these guys to a sudden violent attack. Well, quite frankly, it goes both ways too, right? Because our position is that they were ready, willing and able with a gun in his lap, and within a 1 second period fired a shot. And as it turns out, maybe 2 milliseconds, which will show the jury in court that he fires a shot. So there's no other purpose it can be than propensity. My only point is it becomes also cumulative and prejudicial, as it's required for us to look at for Van Vliet, because we're conceding these points that he's trying to raise.
Mr. Fabian, I gather that your response to that is, no, what I want to offer this for is to show motive and intent, which are exceptions to the usual propensity rule. Is that essentially what your response is to that?
Yes, Your Honor, and I would just add that the other non-propensity purpose and underscore the reputational evidence, which I think is pretty clearly admissible in the case, would be, again, to make it more likely that he was the initial aggressor. But yes, the intent and the motivation are clearly the critical issue here, because we don't know if he knew that he was being shot at by a Velo. That we're speculating about that a little bit, but we do know that he does like to shoot at Beams gang members, and we do know that Jalen Ruffin was a Beams gang member. So he would have been motivated by either one of those two things independently, and he would be doubly motivated to get out of the car and shoot at Ruffin because of that.
So I guess my question then is, if the court allows us, then we should be able to get into the fact that Jalen Ruffin, Bemis gang members, and Uptown gang members like to shoot at Gio Avello and his gang members. I mean, if we're going the one way, or is the court willing to go the other way? I mean, because should we show it 2 weeks prior, and we've shown it we can show it multiple times, that Jalen Ruffin and his gang, which Derek Archie Morris is a part of now that Mr. Fabian knows, they shoot at Gio Avello's gang members.
Mr. Fabian?
Without saying that, Mr. Archie,
In effect, I hear Mr. Loughlin saying, look, that's opening the door. And if the door is open, then it ought to be open for both sides.
Sure. My position is, though, is that Mr. Avello has absolutely no idea that Mr. Archie Morris is in the back seat. There's no known beef, and I don't want to discredit the detective here. She's the lead investigator in the case. She was aware that there was a specific beef between Jalen Ruffin and Mr. Avello. There were no known beefs, no previous shootings that I'm aware of between Mr. Archie Morris and Mr. Avello. So whether he's in a gang or not, and again, there's no evidence that these guys were lying in wait. That was the initial argument. Now it's mutual combat. Whether Mr. Archie Morris was in a gang or not is really irrelevant, because he's not the one being shot at, and Mr. Ruffin isn't on trial. And if there were 404B evidence that the prosecutor was intending to provide, unlike the defense, I wanted to do this out of an abundance of caution. There is a notice requirement for the prosecution 14 days before trial under the court rule. Or the rule of evidence. I apologize. So, I mean, I guess we can hash out those issues as they come up, but at the present moment, I'm just asking to introduce this evidence for a proper non-propensity purpose at the trial, so that I could present a full and fair defense.
Okay. Your Honor, just to highlight that, we don't intend to introduce it as in our case in chief. We would use it as rebuttal for them opening the door. He keeps focusing on Derek Archie Morris in the back seat, but then wants to focus on Gio Avello and his issues with Ruffin for his purposes. Derek Archie Morris was in the back seat and fired a shot and killed our victim because there was mutual beef between Jalen Ruffin and Gio Avello, because he couldn't see Derek Archie Morris in the back seat because he was in a tinted window and sitting with his back to the passenger door. But the fact is that he wants to use it to show that he's a gang member, and that the motive for them to shoot is that they're rival gang members. Well, Derek Archie Morris is a rival gang member with the same motive to shoot Gio Avello. So if he opens the door, then we should be able to use that in rebuttal.
Okay, I think I understand the arguments. I'll issue an opinion in order soon. Now, this trial starts when?
A week from Monday.
November 28th.
All right, so I'll get something out soon. How long do you think this trial is going to take? I mean, best estimate.
I would say 2 to 3 days.
Yeah, we have 8 witnesses we're using, Your Honor. Mr. Fabian and I are planning to meet next Wednesday. Is that correct?
That is, although I might need to shift that a little bit.
Okay. We're going to meet next week so that we can try to ferret through and try to stipulate to a bunch of the evidence to speed up the process.
That'd be great.
I know it looks like we're contentious here, but we're actually get along pretty well.
Oh, come on. I mean, you know, I don't doubt that for a second. I'm sure you had many, many cases against each other. Contentiousness is, I guess, what we're all paid to be, except me. I'm not supposed to be contentious. I'm just supposed to listen to contention.
We do plan to meet to try to stipulate to a bunch of the evidence so that we can expedite the process. So I would say the worst case scenario is 3 days.
Okay, that's fair. It's helpful. I mean, as we get into this time of the year, that's really why I'm asking, because you know, we all have other things that we're trying to get done before the end of the year, including at least one other jury trial. But I appreciate your estimates on that. So again, I take some pride in trying to get things out in a timely fashion. I'll get something out on this one as quickly as I can. Thank you both.
Yes, Your Honor.
very
And
much.
the reason I asked it, because part of the motion was essentially requesting if the court was open to the idea of the September incident. The only way I'd be able to present that evidence, I think, fairly is by having Detective Kubiak, who was the lead investigator on that particular incident, who could testify about the incident, subpoenaed. So I can do that in timely fashion if the court gets an order out before the 28th.
I'll check with him today to see if he's available. I'm only saying that because it's hunting season. I don't hunt, but I know they do. But Pavel, I'll check with him to see if he's available that week for you.
Okay, thank you.
All right, very good. Have a nice weekend, gentlemen.
You too. Thanks, John.
Thanks.
Thank you.
Cases. No, we're not, Your Honor. We also have Miss James here for oral arguments. Do you know what that?
Is James for oral argument? Are you Miss James? You're Miss James. Let me take a look at what this is.
I'm kind of confused myself. I don't see anything other than it's.
What's the nature of the case, ma'am?
It has something to do, I think I messed up somewhere, like, it has to do with unemployment, but it goes back like a couple years. And when I think I was like doing appeals where the money they owed me, I might have accidentally done it too many times or did the wrong button.
This has to do with unemployment. There was a hearing before an administrative law judge. It then went up to the appellate commission. Am I right so far?
I don't know.
You don't know.
When I received the first letter, and it said like I had so many days to respond, or.
Are you represented by counsel?
No, sir. Like I don't know what this is all about. I spoke to a judge before.
Well, hang on a second. We need to hear from Nick on this stuff because I thought I also signed that.
Okay.
I mean, it's possible that I actually issued an opinion in order late yesterday afternoon that may have been emailed out, but hang on a second and we're going to check on that.
Do you want me to call the next? case?
Yeah, why don't
And
you?
if it-
Who are these folks?
they're here for a GM case.
Oh, okay, for guardianship, because as you can tell, folks, we're running a little bit behind, but I promise we'll get there as quickly as we can. I've had a ton of motions this morning.
Can I have that list back? And if Nick has sent something out, are you okay with letting her know instead of having? her
Yeah,
wait
no,
for
I mean,
that?
that's why I said, let's take care of that.
And,
Mr.
thank you.
Buckfire, can you hear me, sir?
Yes, Your Honor.
Mr. Buckfire, I believe, and I'm trying to contact my law clerk that would have gotten this out. I believe that I drafted an opinion and order and that I thought we emailed it out to you late yesterday afternoon. Did you not receive that?
I did not receive it, and while I've been waiting, Judge, I got an email from opposing counsel indicating that the court granted the motion with respect to one plaintiff, but denied with respect to the other. So
that is consistent with my recollection. I don't know why you wouldn't have also received that email.
yeah, I don't know either. And if you know, today was the date set in time for oral argument. If
It was, and of course, the first thing I say in my opinion in order is that I was going to dispense with it under 2.119E3. But I feel badly because, you know, I mean, first of all, I wanted to immediately get to you because you've been very patient waiting for this. But, you know, I try to get things done when I don't think there's the necessity for oral argument, because as you can see, it's a very busy motion day for me. So I try to work a little bit ahead, and when I really am not sure I would be particularly helped. Obviously, oral argument always gives me a different view, but I think I got that out, and I can certainly have it immediately emailed to you if you have not yet seen it.
yeah, that would be great, Judge. And I understand a lot of times courts are able to decide these motions without oral argument, and I have no problem with that. So if you would be kind enough to just have your office email me the order, then I will leave.
We will do that as soon as I am done with my motions this morning. I apologize to you. It did go out, I think, kind of late yesterday afternoon. So it sounds like maybe one side got it and the other didn't, but we will follow up on that and get it to you as quickly as I can.
All right. Well, I appreciate your courtesy, and have a great weekend. Thank you.
Thank you, and you as well. Thank you very much, sir.
Bye-bye.
I'm waiting to hear back from Nick. If I can, I will let her go, but in the meantime, I'm gonna call another case. Your Honor, this is Craig Dyer versus Lowell Osterhaus. This is case 2109544 NI. Please state your appearances for the record.
Good morning, Your Honor. Pappas on behalf of the plaintiff.
And Thomas Cardelli on behalf of defendant Hoffman.
Let's see, and thank you for that.
And Tim Sheridan is connecting right now.
That's exactly the person that I was wondering if he was going to join us, and it does sound as if he's been doing that.
Looks like he's trying to connect to the.
First, let me say I appreciate your patience. We do take criminal matters first. There are a number of reasons why we do that. It has been a particularly busy day and busy motion, and I appreciate that you folks may have been waiting a long time. So I thank you for your patience.
No problem.
Your Honor. These days with Zoom, we can do other work while we wait, so it works
Yeah,
out.
well, I hope that that's true. And
Mr. Sheridan has signed out. He's probably gonna try to sign back.
oh,
Sign back in.
okay, Mr. Sheridan may have given it a try, and he may be trying it again. I mean, I should say, I mean, I don't need Mr. Sheridan to say this. I mean, I was working on this stuff last night. I don't think I got any kind of a response. Did I get a response on this?
No, Your Honor, and the only reason I'm appearing is I don't have an objection to continuing discovery, but we just want to keep some kind of a lid on this case, and maybe if the court would even give us a trial date, because we did try facilitation, it failed. I understand there's liability and fault dispute in this case, but the case has been around some time, and I was just hoping for a trial date to keep a lid on things. But as far as discovery goes, I would not stand in the way of anything that needs to be done.
And Mr. Cardelli, do you take a position here?
Yeah, I concur with Tim Sheridan to get some additional discovery.
Okay, all right. Let's see if we can get him back.
Mr. Sheridan,
Mr. Sheridan, can you hear me? Mr. Sheridan, can you hear me? He's pointing to his.
It is, it's on his end, Your Honor, because we're connected.
We think it may be on your end, Mr. Sheridan, because we've been connected and been able to communicate with others, but I am hardly Mr. Technology. So maybe you can do something so that you can hear.
Now, I can now hear, Your Honor. I'm
That's
sorry.
great. And I can now hear you. So thank you for that.
I apologize, Your Honor.
Nope, that's all right. And so again, this is Craig Dailer versus Lowell J. Osterhaus et al. The motion before the court is to amend the scheduling order and extend the deadlines. And I'm not sure, frankly, that there is any opposition, but let me make this all on the record. Mr. Cardelli, do I understand that you're not opposed to the motion, but that it may just be some details that should be worked out?
No, I concur with the motion.
You concur with the motion?
Yes, it's Mr. Pappas that.
Oh, okay. And Mr. Pappas, again, I gather you do not have an objection, but I gather you've indicated that you would certainly at least like some dates set in the future. Is that, do I understand that correctly?
Right, Your Honor. No objection to continuing discovery through February or longer if needed, but I would just ask for maybe a trial date as early as the court can give after that, because I know it's tough to get to trial. The courts are extremely busy these days, and it would just help to keep a lid on the case and keep things moving.
Well, obviously, if we're going to extend discovery, that means I haven't even had a settlement conference, nor apparently have the parties engaged in any kind of efforts through the possible third-party mediator or something else. Typically,
Judge,
I would give, yes.
Your respectfully, Judge, Your Honor, again, Tim Sheridan for Ustros. We did have a mediation, Your Honor, in September with Tom Bean.
Oh, maybe I did read that, and I gather it was unsuccessful.
It was, Your Honor. I think we're wise. We had a few deps taken then, but did not complete lay witness deps. And I think really that's what's needed. And then frankly, we do have a few experts as well. The only thing I would throw in, Your Honor, I would not oppose at the end of wrapping up that discovery. I would throw out the idea of a case eval. I think that another mediation, I don't think it's going to work. The reason I say a case eval, Your Honor, is then we'd have numbers and evaluations with respect to the liability issue. I think that's really what the issue is. Mr. Cardelli and I respectfully have different views on liability, and that's really the issue. And a case eval at the end of discovery, at least we'd have an opinion of 3 attorneys with respect to the apportionment issue.
A case eval with possible sanctions?
Your Honor, I know the court rule says that's out the window now, so I guess I would follow the court rules. But if there is an agreement with the attorneys with respect to that, I would be open to that. But I just would suggest that option of ADR, Your Honor, than another mediation, because I don't think another mediation is going to work respectfully.
Well, Your Honor, I would oppose that. We would not want to go to case evaluation. We don't need another facilitation either. We don't need a mediation.
Yeah,
it is what it is. We're all experienced.
Yeah, just to chime in, I'm in a unique position where there's 2 defendants in the case, and the plaintiff, I know there'll be some argument about this, but I think it's really a debate about which defendant is at fault. And that seems to be the sticking point whenever we attempt to negotiate this case. So that's the only reason, Your Honor, I was pushing for the trial date that we can get to, because I just don't see at this stage, based on what we've been through so far, a resolution coming from a facilitation.
Well, you're not going to get a trial date for me today. I mean, first of all, my scheduling clerk is out with a sick child today. But so let me just address this issue before we actually go back to the motion. Are all 3 of you telling me that you believe that this case is likely to be tried, and that a settlement conference with the court is not going to get it done? And I gather Mr. Sheridan has some optimism that the case evaluation, which of course does not carry sanctions anymore, unless that's by agreement, it doesn't sound like we're going to get that, is likely to resolve it. So should we just anticipate that the case is going to be tried and get you the earliest trial date that we can get?
Yes, Your Honor.
I think that sounds accurate, Your Honor.
All right. Are you able to do that, or is that really Kathy?
That's Kathy. I'm not sure what she has said where.
Yeah, so in the meantime, it also sounds to me like there really isn't any disagreement or opposition to the motion. And so, can the three of you agree on extended dates that hopefully work out for all of you with respect to discovery extension? And then when my other judicial assistant is back into the office on Monday, then I can ask her to find the first available date. I mean, I have to tell you, we're still catching up from COVID, and it's not going to likely to be right around the block, if you know what I mean. But I'll ask her to find the first available date.
I think we can, Your Honor. The three of us, I think we can work that out. We can disagree about liabilities, but I think we can agree upon dates, Your Honor.
That would be great. So if you folks can just submit a stipulated order extending the dates from the extant scheduling order, and then in the meantime, I'll ask Ms. Vasquez, who will be in back on Monday, to schedule a trial date. Now, we will, even if there isn't a settlement conference, we will schedule a final pretrial conference, because my practice typically is that at the settlement conference, if the case doesn't resolve, then I issue a trial order, which supersedes and supplants the scheduling order. And there are a number of things that I have in my trial order, and I don't need to go through this with you now. I will say that I'm a big fan of motions in limine. I don't like making decisions during a trial, especially in front of a jury. And so I ask that any potential evidentiary issues be brought so that I can decide them before the trial begins. But that will all be spelled out in the order. So if you folks think you can get this worked out with what we're talking about, and then we'll get you a trial date, is there anything else anybody wants to bring up while we're all here?
Just, Judge, again, Tim shared, to be clear. So when we put this together, we should have number one, a discovery cutoff date. And then number two, we should, after that, some period of time, a final pretrial conference date, of which is not a settlement conference, but is a date in which you'll give us a trial order, it sounds like.
Yeah, I think that's right. I mean, it certainly doesn't preclude possibilities of settlement at that point. And I don't think you mean it that way, but it wouldn't be scheduled as a settlement conference. Let me tell you what my practice has become. I mean, I've been a judge a long time. I'm finishing my 4th year in this division. And my practice at this point is that we set scheduling conference dates, and I literally have my staff call counsel and say, the judge doesn't want to waste his time. If this is a case that you really believe the court could assist people to resolve, he's more than happy to put in the time. But I don't want to spend my time and waste anybody else's time. If we do, it's typically, a Zoom kind of a settlement conference, and it's clear from the very beginning that you're so wide apart that it's like, you know what, I got a whole lot of other cases to work on. So, my job is to try to resolve cases, but if the counsel agree this one's not likely to be resolved, then just let us know that, and you can work on your trial prep, and I'll move on to all my criminal and civil cases. So that's sort of the way I operate. But yes, I mean, a final conference would be helpful. You may want to wait until we can get you the trial date, which hopefully would be Monday, and then you'd have a better sense of when a final pretrial could be held, so that it's sort of a precursor to the trial. And of course, I always hope that people continue to talk, but it sounds like there may be some intractable issues here.
No, understood. What's typically, Your Honor, your experience, that gap between the final pretrial conference date and start of trial? We're talking typically a month? I
would say probably 6 to 8 weeks.
Okay.
And then everybody knows, exactly, what I expect with respect to actually the trial beginning. It gives everybody, a month and a half, or maybe even 2 months to get it all together, to get the things filed, joint jury instructions in civil cases, and a lot of those kinds of things. But you guys are all experienced lawyers, so none of this will be a surprise.
Sure.
Okay.
No, that makes sense, Judge. I'm happy to take the lead and get that, have my assistant speak to the assistant there at the court's office on Monday or Tuesday, get that date, and circle back with these gentlemen to get the ball rolling.
That would be great. Again, I appreciate your patience this morning. Have a nice weekend, guys.
Thank you.
Thank you.
Thank you, Your Honor. Same.
Is that is our motions now done?
That's it, Your Honor. Just go out on the other. You can have a seat right there. You can go over.
You have those.
I do, I just.
Folks, I appreciate your patience. It's been a very long morning. And I try to get the Senate criminal motions done with a little bit of a break, but I get paid to work and I'm not complaining about the break, but I know many of you have been here.